Thank you very much for joining us after lunch to the session on the adjudication of the war. And first of all, I want to thank Danny and the Minerva Center for organizing this conference and for letting me take part in it. And I will introduce each speaker before their presentation, and they have 20 minutes or so to speak, and then we'll open the floor for questions. So our first speaker is Professor Monica Polzin. Is the head of the Institute for the Internalization of Law and professor of public law and public international law at the Vienna University of Economics and Business in Austria. Monica is acting as a legal expert for national and international institutions and has published widely in national and international peer-reviewed journals in English, German, and French, in particular on the constitutional identity, constituent power, and the interpretation and autocratization of international law. Monica, you have the floor.
In European Union law, it is discussed whether a decision of the European Court of Justice becomes inapplicable if it is seriously legally flawed. And the doctrine discussed here is the doctrine of alter virus. Alter virus is understood generally in the sense that a court oversteps its competences if the decision is manifestly and objectively arbitrary. In this regard, I will discuss today the question whether the three orders adopted by the ICJ in the case on the application of the Genocide Convention in the Gaza Strip are alter virus acts. In order to answer this question, I will focus first on the three most important legal flaws. The first flaw is the vague but still progressive application and understanding of the Genocide Convention, which in my mind cannot be reconciled with the rules of interpretation in international law. And I will then deal with the very broad and also novel application of Article 41 of the ICJ statute, which leads, in my view, to a circumvention on the rules of state responsibility for genocide. And I will then consider briefly the effect of A and B before turning to the final question whether we can talk about alter virus acts or not. I start with the Genocide Convention. Now, the Genocide Convention defines in Article 2 the crime of genocide. And the core element of genocide, as you all know, is the genocidal intent, which also distinguishes genocide from other international crimes like war crimes and crimes against humanity. And the Genocide Convention that sets out in Article 3 possible acts that shall be punishable. That's not only genocide, but also direct and public incitement to genocide, or, for example, the conspiracy to commit genocide. Though the state obligations are contained in Article 1. According to Article 1, the states are obliged to prevent and to punish genocide. And according to the ICJ, these obligations contain also the obligation not to commit a genocide. The particularity of the orders of the ICJ is now that all orders are silent on the question of genocidal intent, and they also do not specify which acts in the sense of Article 1 of the Genocide Convention are relevant in the case. As you all know, South Africa is arguing in essence that Israel committed or failed to commit a genocide in Gaza, and therefore requested the International Court of Justice to indicate provisional measures. The ICJ granted some of the interim measures requested by South Africa based on the Genocide Convention. Generally, if the ICJ wants to adopt interim measures based on Article 41 of the ICJ statute, the court has to be satisfied that the rights claimed by the respondents are at least plausible. Here, in the first order of the 26th of January, the ICJ decided that at least some rights which South Africa claimed, and in respect it was seeking protection, were plausible, and the court stated, this is the case with respect to the right of the Palestinians in Gaza to be protected from acts of genocide and related prohibited acts identified in Article 3 and the right of South Africa to seek Israel's compliance with the latest obligation under the convention. The ICJ now confirmed this conclusion with 3 arguments, but with no elaboration on the question of genocidal intent. The first argument was that the Palestinians in Gaza are a protected group in the sense of Article 2 of the Genocide Convention. The next one was the scope of destruction in Gaza, and the third one were 4 statements by Israeli senior officials. These statements, however, the court does not say for which requirements in Article 1, 2, or 3 these statements are used. And the statement that you all know probably much better than me, I think they cannot be used in order to show implicitly any form of plausibility of genocidal intent, because these statements primarily relate to Hamas, and they are highly ambiguous regarding the Palestinians in general. This approach, adopted by the order in January, was then affirmed by the next 2 orders. And the next 2 orders, in March and May, they adopted even scantier approach regarding the plausibility of the rights in question. The next 2 orders were based on Article 76 of the ICJ Rules of Procedure, which allow the ICJ to modify interim measures if there's a new situation. The ICJ said in both situations, both orders, there is indeed a new situation, but it did not elaborate whether the rights in question were plausible in the new situation. It remained completely silent on this question. Though the ICJ is dealing with the effects of the military measures in Gaza, but does not elaborate on the question on genocidal intent. Therefore, it treated as a dispensable criteria for interim measures. Though the question is, what does this mean for its understanding of the Genocide Convention? I think as the orders are also silent on the question which obligation under Article 1 of the Genocide Convention might possibly be breached by Israel, it is possible to interpret these orders in 2 ways. Either they refer to very broad understanding of the duty not to commit a genocide, or to a very broad understanding of the obligation to prevent. If one understands the orders as referring to the duty not to commit a genocide, and the question of genocidal intent is not discussed and is treated as dispensable here, this means that the duty to commit is understood as also including an obligation to prevent serious humanitarian crises in armed conflicts, so that acts that might possibly fall under Article 2, litera A to F, in particular litera C, of the Genocide Convention are generally avoided. However, it is also possible to understand the orders as referring only to the duty to prevent a genocide. This was the argument made by Judge Nolte. If one understands this order in such a way, it is possible, because if one say they relate only to the duty to prevent, it is not necessary to elaborate on genocidal intent, because the question to prevent a genocide arises, according to the ICJ case law, at a very early stage. I cite, it arises at the instance that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. However, even if I say it relates to the duty to prevent, it contains still a very progressive interpretation of the duty to prevent. Generally, the duty to prevent is understood in very vague terms, that the state has to do its best to prevent a genocide. So in the present case, it would be understood as a duty of self-prevention in an armed conflict. And more concretely, it is understood as a duty to halt or not to cause serious humanitarian crisis in an armed conflict that increase the likelihood that acts within the meaning of Article 2, litera A to E, in particular litera C, might be committed. This leads me to the conclusion that in either way, the ICJ interprets Article 1 very broadly, namely in a way that Article 1 of the Genocide Convention contains an all-encompassing due diligence obligation to prevent serious human suffering in armed conflict, with the ultimate goal to prevent that a genocide might occur. I think such an interpretation of the Genocide Convention cannot be reconciled with the rules of treaty interpretation. I think, firstly, such an interpretation is inconsistent with the wording and purpose of the Genocide Convention, which is to prevent the ultimate crime of genocide, which is characterized by genocidal intent. And it's not the purpose of the Genocide Convention to prevent human suffering in armed conflict. The Genocide Convention purpose is not to regulate armed conflicts. Furthermore, I also think such reading cannot be reconciled with Article 31, Paragraph 3, litera C of the Vienna Convention on the Law of Treaties, which requires to take into account all other public law rules while interpreting a treaty that are applicable. Because here, such an interpretation disregards the specific obligations for preventing human suffering in international humanitarian law. This was my first legal flaw, and the next legal flaw is the flawed application of Article 41 of the ICJ statute. The core reason is that the ICJ did not limit itself to adopt general provisional measures, which are repeating in principles the obligations contained in the Genocide Convention. This was done by the ICJ in particular in the first order. It made interim measures, but they only repeat the general obligations already contained in the Genocide Convention. But the ICJ went one step further, in particular in the second and third order. Here, the ICJ adopted specific interim measures, going beyond repeating the general obligations of the Genocide Convention to increase humanitarian aid and to maintain the Rafah crossing open, or the very ambiguously phrased interim measure regarding the hold of military measures in Rafah. And I think here the ICJ is circumventing the rules of straight responsibility for genocide. Because it is, in general, public international law, it is undisputed, it is also decided by the ICJ and supported by legal academia, that a state is only liable for a genocide if a genocide actually occurs. So, if a state has a duty to prevent a genocide, and in the end there is no genocide, a state is not liable under the rules of international state responsibility. And this is circumvented here, because the ICJ adopts specific interim measures, and these are binding. And if a state is breaching them, he becomes internationally responsible. So this principle is circumvented. And the particularity is also that the ICJ is not explaining this approach, and is also a novel approach. Even though we know special interim measures, that were also adopted in armed conflicts by the ICJ. In the previous cases that concern genocide and the obligations under Article 1, the ICJ limited itself to repeating the general obligations contained in the Genocide Convention and did not adopt specific measures. Oh, I've forgotten to change. Then I'm coming to the next issue, the combined effect of this vague but progressive application of the Genocide Convention with this novel and broad application of Article 41 of the ICJ statute. This has allowed the ICJ to create a new role for the court. The court is no longer applying or interpreting the Genocide Convention as he has the power to do according to Article 9 of the Genocide Convention. The court is now acting as an ultimate genocide prevention body, because he looks at the armed conflicts and he established preventive duties that are binding by interim measures, which the court has adopted in order to enforce its broad and progressive application of the Genocide Convention, that it should be applied in order to minimize human suffering, in order with the ultimate goal of minimizing risk for genocide. Or we can say that in the words of Judges Sebutin and Barak, the court is now acting as a micromanager of an armed conflict. So the final question is this an ultra-virus act? Unfortunately, in international law, there is no established doctrine when we can talk about an ultra-virus act. The legal literature is quite silent on this issue in international law, because international lawyers tend to see the ICJ as something intrinsically good, though this is different in European Union law, where there's a lot of criticism of the European Court of Justice. Therefore, I would like to apply the ideas of ultra-virus as developed in European Union law, and also we find much the same ideas in international arbitration law, that there can be ultra-virus decisions. And these ultra-virus decisions happen when the court makes a decision that is objectively and manifestly arbitrary. And the reason for this arbitrariness is a manifest false application of the law based on an untenable interpretation, caused in particular by a severe misapplication or disregard of the relevant interpretation rules. And I think that here there are good, strong arguments for an ultra-virus act, because the court remained silent on the question of genocidal intent, which is the core element of genocide, and does not explain it. This leads to a vague reasoning, but this reasoning can still only be understood as a progressive way reading the Genocide Convention that in my mind cannot be reconciled with the rules of treaty interpretation. And this is then combined with this novel and broad application of Article 41 of the ICJ statute, which circumvents the rule of state responsibility, again, which is not explained and which is unique in the case law of the ICJ. And the combined effect create indeed this new role of the ICJ I just explained. However, I think a final assessment is so difficult to make because we have now established ultra-virus doctrine in international law. This leads me to my final conclusion. I think these orders are a very sad moment for international law, because international law is indeed twisted. And the orders make visible a risk that although international judges might pervert and misuse international law. And this is a very concerning development in current times, where the liberal elements of the international order are anyway challenged by the increasing power of the authoritarian state like China and Russia. Therefore, I think it's very important that these orders are strongly criticized. And it's also very important that international lawyers develop a robust doctrine of ultra-virus for the International Court of Justice and international courts in general.
Our second speaker is Ms. Yara Mordechai, who is a JSD candidate of Yale Law School, where she earned her LLM degree in 2023 as an E. David Fishman Scholar. She also has an LLM and an LLB from the Hebrew University. Her dissertation explores the intersection of poverty and crime, with a particular emphasis on evaluating alternative enforcement approach to traditional crime methods. Before coming to Yale, Yara clerked for the Deputy Chief Justice of the Israeli Supreme Court and worked as a lawyer at the Justice Ministry International Law Department. Please, you have the floor.
So thank you for being with us. It's especially exciting for me to be here today. I used to be one of the students helping to organize these conferences not too long ago. So it's a really special pleasure and honor to be sharing my work with this respected forum. So today I'm gonna talk about an issue of profound legal and ethical implications, and that is the topic of how we can prosecute the perpetrators of the October 7th attack while maintaining the highest standards of fairness and preserving international legitimacy. So as you may all know, on October 7th, Hamas orchestrated an unprecedented attack on Israel, carrying out acts of extreme brutality that included grave violations of international criminal law. These acts constitute crimes against humanity, war crimes, and arguably the crime of genocide. And the aftermath of this attack left us with an immense challenge, and that is to effectively prosecute the thousands of perpetrators captured and detained from October 7th onward, some of them within Israeli territory during the day of the attack, and others during the subsequent ground operation Israel conducted in Gaza and is still conducting, while ensuring that the legal process remains just, impartial, and in accordance with international legal standards. In my paper, I examined 3 potential avenues for prosecuting these perpetrators. And additionally, I discussed how we can mitigate the risks of show trials by drawing on established precedents of atrocity trials. I specifically focus on Nuremberg trials, more recent examples of special ad hoc tribunals of the ICTY and the ICTR, adjudicating the areas of former Yugoslavia and Rwanda. I also look at the Special Court of Sierra Leone and other special courts, and our very own Eichmann trial. So before I start, I just want to kind of substantiate the legitimacy of Israel even conducting these proceedings. I know that there could be arguments of this becoming some kind of victor's justice kind of proceedings, so just I'll briefly go over that and just say that Israel has very clear jurisdiction over the case. The crimes of October 7th were committed on Israeli soil against Israeli citizens. And the perpetrators of the attack are under Israeli custody. And the principle of complementarity also plays a role here. Obviously, Israel is not a party to the Rome Statute, but it does regulate the relationship between the adjudication of international crimes in international courts and domestic courts, with the primacy of the state nation adjudicating these crimes really beforehand, and having these crimes being adjudicated as a last resort if the state is unwilling, unable to genuinely conduct these proceedings. There are also obviously practical consideration, access to witnesses, to evidence. And there's also the issue of the impunity gap or NSA accountability that was discussed here yesterday. We know that the International Criminal Institution adjudicating international crimes of this gravity usually go after the people most responsible, the high-ranking officials, and here we really have the opportunity to bring to justice those lower rank militias who committed this attack, thereby fulfilling this inherent impunity gap, and also creating maybe kind of an equalizer of this asymmetry that we talked about states being held very accountable for their actions, and NSAs, on the other hand, not really. And lastly, we talked about feelings. So there's a really significant symbolic meaning to Israel conducting these trials for the Israeli public, for the victims of the attack. There's extensive writing about these kind of trials, really supporting healing of a nation, even if you want to say reiterating the social contract between the states and the citizens, especially in the face of the failure of the state to protect Israeli citizens on that day. So these are also considerations to take into account. And as per claims that it's seemingly one-sided, that Israel would be trying the Palestinians during an ongoing armed conflict, then I think it's important to mention that it's not, Israel is not absolved of accountability for what it does and for its actions during this ongoing war. So we've talked about how Israel is under intense international scrutiny. It could be legal international scrutiny by international institutions, the ICC, the ICJ, diplomatic scrutiny, other international institutions such as the UN that we've talked about, and the different arms of the UN, NGO-led scrutiny and media-driven scrutiny. So the actions of Israeli officials and soldiers are being looked at very closely. And also, I think some of us kind of tend to forget it, especially under this current government, but Israel has its own judicial accountability mechanisms that are working, even though while the cannons see war, right? So we have the Israeli Supreme Court adjudicating cases related to this ongoing conflict, and we have, even military disciplinary mechanisms who are looking into actions, hopefully. Again, it's not perfect, but hopefully looking into actions of the soldiers on the ground. And that's another hope that we have, that we will establish a national commission of inquiry, hopefully looking into the events leading to October 7th and our actions afterwards. Okay, so with this not so short introduction, I'm gonna talk about some of the legal venues for prosecution that have been identified thus far as options for conducting this proceeding. So the first option would be through the regular criminal justice system. That means trying these detainees just like any other criminal offender. The second option that has been brought up is trying them through military courts. And the third option is establishing a special tribunal. Now, each option really offers unique advantages and challenges and different legal frameworks with different punishments that result from this legal framework. I don't think I have time to dwell into the pros and cons of each, but I would just state them briefly. In terms of domestic criminal system, well, I think that at first glance this seems to be a good option, as we already have established legal frameworks. It nullifies the need to draft new legislation. Judges are trained and well suited in adjudicating these types of offenses. I would say that would probably be the option that would garner the most international legitimacy and support, just because of these reasons. But then on the other hand, we have systemic limitations that really render this option inadequate for adjudicating atrocity crimes. So first, there's a practical issue of system overload. The system is already extremely burdened with cases. Adjudicating thousands of offenders through the regular channels would create a significant backlog, and I'm not sure it's even feasible. And there are also substantive challenges, merely the fact that we don't have in our penal laws and in complementary laws offenses that really suit the kind of crimes that we've witnessed on October 7th. So there's been a lot of critique on Germany post-World War II for trying Nazi war criminals under offenses such as murder. And the critiques were saying these type of offenses do not reflect the gravity and the nature of the crimes that were committed during the Holocaust. And I think that the same thing can be said on the crimes that we've seen on October 7th. So the substantive law is also fails to capture the scale and the systemacy in which these crimes were committed. And if we look at the option of military courts, again, on the face of it, I think this option garners a lot of support within right-wing sectors here in Israel. In terms of subject matter jurisdiction, military courts seem to fit quite neatly because they tend to adjudicate security-related offenses. They adjudicate Palestinians in the occupied territories, and they work under emergency regulations that offer enhanced penalties and flexible procedures, and that these procedures also tend to be very efficient. For instance, there's no limitation on the number of defendants that can be tried in the same case, so that could really help promote the proceedings. But here again, we have significant disadvantages that are also, the flip side of the pros here, and that is that we have outdated legal frameworks. Again, the offenses that we see in the emergency regulations are offenses that are often consequence-free. There's even a possibility to impose death penalty, but just by kind of an attribution to an organization that holds weapons, something very far removed, again, very flexible, maybe probably too flexible. So the offenses are also inadequate for the type of crimes that we've seen. There are high conviction rates, fewer procedural safeguards, and there's a real fear of systemic bias within the military courts and also perceived bias. This is probably the option that is expected to draw a lot of controversy. So again, not the best option. So here I have to, this is the third option that seems most reasonable, and that is the establishment of a special tribunal that would acknowledge the extraordinary crimes and an event that has taken place. This seems to be the option most favored by the Israeli government and the Ministry of Justice as of now. So about a month ago, Knesset member Simcha Rotman and Yulia Minkovsky have submitted a draft bill in which they kind of show us how they envision this special tribunal. But this seems to be what will actually, the option that would actually be chosen. And so in terms of the advantages, again, this will allow us to really signal the importance of the event, how extraordinary it was, and also tailor legal framework that specifically suit the situation on the ground. But in terms of the cons, right, the disadvantages, this still leaves unresolved the question of the proper legal framework through which we're going to work, and it doesn't solve questions of legitimacy concerns. And here I address a concept called show trials, and I try to think about how the state of Israel in conducting these procedures in the special tribunal can avoid the pitfalls of a show trial. So show trials are defined in the literature, I like that definition, as rituals of vengeance, but basically it's the attempt to use the ritual of judiciary and the facade of a judicial process to instrumentalize it with the goal of spreading political propaganda, eliminating political opponents, and focus on image creation, manipulate the public's opinion instead of, serving justice, accountability, truth-seeking, and make sure that the trial is fair, etc. So I think that specifically these procedures, again, under this specific government, are really at high risk of becoming this kind of show trial and spectacle, because the time that has elapsed since October 7 is not too long, and because we're still in combat, and there's the potential risk here is real. And so what I do is I offer best practices with regards to these elements. And these, as I've said, are drawn from past precedents of the adjudication of atrocity trials, both domestic and international. So I won't have time to delve too much into each of them, but I can just say, I can just kind of state my suggestions in bullet points, and we can discuss it later during the questions. So as for the composition of judges, I offer a hybrid approach, which interestingly, even in Simcha Rotman bill proposal, he also left the door open for international justices to become part of this special tribunal. And I would even like to offer that the international judges that would join would be the majority of the panels adjudicating these cases. Another thing that we need to look at is the issue of legal representation. I'm sure you've all heard that the public defense in Israel has kind of expressed its reluctance to represent these detainees. And lately, a bill has passed stating that Israel will not fund the legal defense of these detainees. This is not unprecedented. Also, in the Eichmann trial, we've had the same situation. Although Israel did pay for the foreign German lawyer to represent Eichmann. I think this passes legal scrutiny. It's fine. I don't think Israel has to pay for the legal funding, but we do have to make sure that we offer and that these detainees are in fact represented and have legal defense, and that we make sure that the principle of equality of arms is being preserved. That means that these detainees should have their day at court, should have the ability to prepare a defense, to be heard genuinely by the justices, etc. And as for the applicable law, which is a really big question, again, here I offer a hybrid approach. That means combining domestic law and international criminal law. That's not unprecedented. So in the ICTY and the ICTR, we had the statute that established this court really did the same thing, a hybrid approach. There's a question of retroactivity, or the principle of non-retroactivity. It's important to state that Israel does have a law against genocide. So I don't think we'll have a problem with this specific offense, even though we have other problems with that specific crime. But we will have to integrate the crimes against humanity and war crimes into this statute. I can talk about non-reactivity later if you'd like. I don't have much time, just on the issue of the death penalty, an issue that has also raised a lot of controversy in this regard. I strongly recommend against the imposition of the death penalty during these procedures. There are all the usual reservations against it, the fact that it's cruel, it's not really deterrent, there's a high possibility of mistake, and all these other issues. I would just briefly state that specifically on the issue of October 7th, I think the Israeli public, and even maybe some of the global community, we got our absolute revenge in the sense that there were de facto, I don't want to say executions, but the people who orchestrated the October 7th attack are now under the ground, as well as more than, according to Israeli numbers, to the numbers of Israeli officials, more than 10,000 Palestinian belligerents who have died during the hostilities. So I don't think that pictures of mass executions of those detainees or convicted felons maybe in the future would be the kind of image that we'd like people to remember out of these trials. So that's on the death penalty. There are other issues I can discuss, but don't have much time. So just to conclude, I think that these trials are really a watershed moment, as I call them, in Israel's judicial history. It's one of the biggest, if not the biggest, legal challenge, not just legal, but also legal challenge that I think the country has faced its establishment. And I just want to reiterate that we have to make sure that we balance between accountability and fairness and avert the dangers of show trial as much as we can. There's that there's that known saying that hard cases make bad law, and I just want to say this is indeed a hard case, but it could actually lead to good laws, because I see these proceedings as an opportunity for national healing, as we've stated, but also for the development of warranted international and domestic legal norms. So thank you so much, and I look forward to your feedback.
We have now two co-speakers who are joining us online. We have Dr. Alexander Wenker as a senior research fellow at the Max Planck Institute for Comparative Public Law and International Law. He teaches public law and international law at the Humboldt Universität de Berlin and Freie Universität Berlin, as well as University of Heidelberg and Potsdam. And we have also Dr. Robert Stendhal, which also a senior research fellow at the Max Planck Institute for Comparative Public Law and International Law, and the managing editor of the Heidelberg Journal of International Law, which now you have the floor, so please join us.
Once again, thanks very much for the introduction. And thanks very much for having us. And sorry for the little mess up here. We very much regret not being able to be with you in Jerusalem in person. I mean, I still have very fond memories of the conference 2 years ago. But I should also actually thank my students, because I should be teaching in this very moment, and they kindly agreed to push the class back until after the panel, so Robert won't have to present the paper on his own. Now, as you all know, the ICJ is busier than ever, and this is in part because states have begun bringing so-called public interest cases to the court. And by that we mean the litigating interests of the international community as a whole. Now, in legal thought, international laws move from bilateralism to community interest is something that has long been theorized, but it's really only in recent years that this theoretical analysis has also been put into sizable litigation practice before the court. Now, so far, litigating community interests has mostly meant that states that are not directly injured bring cases against the alleged wrongdoer. So, for example, the Gambia has sued Myanmar for alleged breaches of the Genocide Convention against the Rohingya minority. And of course, South Africa has sued Israel for alleged breaches against the Palestinian people, again, breaches of the Genocide Convention, to just give 2 examples. But we can push that notion that community interests can be litigated between all states further. And that would mean that such litigation may not only involve an expanded range of applicant states, but also potentially a broader range of respondent states. And this new dimension of public interest litigation is what we focus on in our paper. And the first case that falls into this dimension is Nicaragua's case against Germany for supporting Israel's alleged violations of international law in the Gaza Strip. Now, as a matter of substance, of course, international law long has rules that allow for holding states responsible as facilitators or bystanders of another state's wrongs. These rules include prohibitions of aiding, assisting, or encouraging violations of international law, as well as duties of prevention and of vigilance. Now, some of these duties are illustrated by the case between Nicaragua and Germany, but not all. And what we're here interested in is a general analysis rather than a case study. Now, this is the substance, but from a procedural perspective, there is a question as to whether the ICJ may be barred from adjudicating violations of such duties. And this is because the primary wrongdoing state could be an indispensable third party under the ICJ's monetary gold rule. Now, as you all know, the ICJ has coined this rule exactly 70 years ago, and it says in a nutshell that the court may not exercise its jurisdiction if it would have to determine the legal position of a state that is not a party to the dispute. So the court, that would mean, in this case, the court could not rule on Nicaragua's claims against Germany to the extent that doing so would require the court to determine whether Israel has complied with its obligations. And as odd as such a rule may appear, from a domestic adjudication perspective, the ICJ's jurisdiction is based on state consent, like any international adjudication. And the rationale of monetary gold is precisely that it would run counter to sovereign equality to adjudicate the rights and duties of a state that has not consented to that adjudication. Of course, the monetary gold rule has faced considerable criticism in the literature, but the ICJ has held onto it. And so rather than debating whether the rule should exist, we start from the premise that the rule does exist. And the more pressing issue then is how the rule applies to this new dimension of public interest litigation. So this is really what we try to uncover in our paper. And to do so, we develop an analytical framework that distinguishes different types of rules for holding facilitators and bystanders responsible. And our central argument is that the structure of the obligation of the respondent state will determine to what extent monetary gold bars the ICJ from adjudicating a claim. The key distinction to our mind is between derivative and non-derivative duties, by which or to which we also refer to as inchoate duties. Derivative duties can only be violated if the primary wrongdoer is found to have breached international law in the first place. Inchoate duties do not depend on that finding. And what we'll do in the remainder of the presentation is just to briefly explain our analytical framework by walking you through the most relevant types of duties for holding facilitators and bystanders responsible. That is, duties that states bear regarding the conduct of other states. And what we'll glean from that is a quite nuanced picture. So non-assistance and non-encouragement duties will fall under the monetary gold rule, and so will some, but not all, duties of prevention, and crucially not at all stages of the case. And we'll also see that duties of vigilance can always be adjudicated. In a final step, we'll then show that there are certain procedural strategies that can help further evade some of the constraints of monetary gold. So let's briefly go through the main types of duties regarding other states' conduct. I'll begin with duties of non-assistance, that is complicity, and non-encouragement, that is instigation. And then Robert will take over with duties of prevention, duties of vigilance. So duties not to assist another state's wrongful act, complicity type duties, they are really derivative par excellence. You can only violate your duty not to aid or assist in violations of international law if there are such violations in the first place. So Germany can only be found to be complicit in Israel's wrongdoing if Israel breached international law in the first place. And that is, of course, true not only of the general complicity rule reflected in Article 16 of the ACIVA, it's also true of all special complicity rules that may exist in particular subfields of international law, including, for example, complicity in genocide under Article 3E of the Genocide Convention. The key question will be whether a particular duty of non-assistance is actually structured as a complicity rule. So, for example, Nicaragua also alleges that Germany violates its duty to ensure respect for IHL under Common Article 1 to the Geneva Conventions, of which we've already heard earlier this morning. And the ICRC reads that general duty to include a duty of non-assistance with a complicity type structure. But of course, the wording, ensure respect, is broad, and that broad wording probably doesn't settle that granular point of structure as to whether the rule is derivative or not. Now, our point in the paper is also not to settle that specific point of structure of the particular rule, but rather to demonstrate the relevance of the rule's structure for the ICJ's ability to adjudicate. Secondly, then, very briefly, duties not to encourage violations of international law, that is instigation. Well, as you can see, they're not relevant in Nicaragua against Germany. And in very general terms, instigation rules look just like complicity type duties from a monetary gold perspective. That is to say, they are derivative because they're only violated if the act that you encouraged actually occurs. And I think in the interest of time, I'll leave it at that for instigation and hand over to Robert for duties of prevention.
So also hello from my side, and also I'm very sorry that I cannot be with you in person. I would very much like to be there, and hope there will be another occasion to come to Jerusalem. For the time being now, I'm turning to the third type of duty, and that is the duty to prevent. So some duties require states to take steps to prevent a certain event from occurring, and whether such a claim based on a duty to prevent falls foul of the monetary gold rule, again, as Alex already has explained, hinges on the structure of the rule in question. Now, with duties of prevention, there are at least two ways to construct these rules. They may either be conceived of as due diligence obligations or as negative obligations of result. That is to say, they either prescribe a certain conduct or they require a certain result to occur or not to occur. Importantly, there is no one-size-fits-all approach, as also the ILC has acknowledged. Rather, it really depends on how the specific duty is framed. For one very important duty to prevent, the duty to prevent genocide, the ICJ has actually already elaborated on its structure. In the Bosnian genocide case, the ICJ held that the duty to prevent genocide kicks in as soon as a state learns of or should have learned of a serious risk that genocide will be committed. Afterwards, the state has to exercise due diligence in taking appropriate steps to prevent the genocide. Yet, and that's very important, the state will only incur responsibility if the genocide actually occurs. If we follow the ICJ's reasoning here, monetary gold will bar the court from adjudicating claims based on a duty of prevention if the alleged genocide was committed by a state. However, the ICJ's conception of Article 1 has one important implication for public interest claims, such as the one initiated by Nicaragua. The court could very well indicate provisional measures based on the duty to prevent. This is so because the court would only need to find a risk of genocide at this stage. Here, no finding on the rights and duties of the third state is required. Similar to Article 1 of the Genocide Convention, Common Article 1 is often understood as a duty to prevent other states from committing violations of IHL. The precise structure of this rule is yet unsettled, but there may be good reasons to transpose the ICJ's conception of Article 1 Genocide Convention to the duty of prevention under Common Article 1. Essentially, this would mean that monetary gold would bar the court from adjudicating such claims at the merit stage. Importantly, the result is different if the duty of prevention does not require a certain wrongdoing by another state. So it really hinges upon the specific duty in question, whether monetary gold bars adjudication of such claims based on duties of prevention. There is then a fourth type of duties, because there is a more recent trend towards proceduralization in international law. We see further duties of vigilance or monitoring vis-a-vis third state behavior. And importantly for our purposes, these duties may not require an assessment of the third state's rights and duties altogether. The Arms Trade Treaty is a useful example here because its duties are closely connected to non-assistance duties under the Genocide Convention or Common Article 1. Parties are under an obligation not to transfer or export certain weapons if there is a risk, for example, of IHL violations. Crucially, the duty would be violated even if no violation of IHL were to occur. So differently from the assessment of claims based on the connected duties under IHL or the Genocide Convention, monetary gold would not bar adjudication. If we turn to Nicaragua's claim, that would mean that it could avoid monetary gold issues for some parts of its claim simply by joining the ATT, which it's not a party to at the moment. Given the wider trend of proceduralization in international law, we can expect such duties to increase and in turn provide more room for public interest claims. Overall, we see that monetary gold does not systematically bar public interest litigation, but much depends on the exact structure of the rule in question. But even if the duty is derivative in nature, there may be ways to get around monetary gold. I will highlight at least one way to do that. We can come to more in the discussion. So first, if the rights and duties of the third state had already been decided by the ICJ could rely on these findings and treat them as givens. Indeed, the ICJ has hinted at this possibility before in East Timor. For findings in a contentious case
you have 5
against the third
minutes.
state, this is convincing because the third state has consented to adjudication. And consequently, findings in an ICJ judgment between South Africa and Israel on the allegations of genocide could be treated as givens between Nicaragua and Germany. An ITLO special chamber in Mauritius versus Maldives has extended the reasoning of the ICJ to advisory opinions. This may have far-reaching implications for public interest cases before the court. But the ICJ has given such opinions in instances which the ICJ could not have decided in a contentious judgment due to a lack of jurisdiction. This is well illustrated by the Chagos advisory opinion and the recent advisory opinion on Israel's policies and practices in the occupied Palestinian territories. So if the ITLOS Chamber's reasoning were to be followed by the ICJ, this would give states quite an important procedural tool to work around monetary gold. All in all, our analysis shows that the monetary gold rule can be adjusted to public interest litigation. Doing so, we can strike a balance between respect for sovereign equality in interstate dispute settlement and the need to enforce community interests in court. Thank you very much for your attention and looking forward to a fruitful discussion.
Okay, great. Now we can open the floor for questions, and I call all speakers.
Well, thank you all for wonderful talks. My first questions are directed to Professor Polzen. I really appreciate your very careful analysis and critical analysis of the reasoning of the court, the ICJ, in the interim measures. But I find it very, very difficult to accept your conclusions that this could be a case of ultra vires. I am not familiar, I must say, with the European, but I'm very familiar with the common law idea. And one thing is clear on the common law. You can never say that the court exceeded its authority on the basis that the court was mistaken in its interpretation of the law. That is never a basis. The one problem, of course, is that you don't have an appeal system. In our system, if the court makes a mistake, you appeal. But I do not see any grounds for what you've said for concluding that the court was acting ultra vires, and I think it's a very, very dangerous doctrine, because if we were to create a doctrine of ultra vires, you'd have every state which does not like the decision of the court to say the court acted ultra vires, and I'm afraid to say that's a situation which we have domestically now in Israel, which we have a Minister of Justice. If you decided that that was the position in international law, that's what he's saying exactly here. So I would be reluctant to reach your conclusion. Now, Yara, two comments for what you said. The one is about the military courts. And I think there's a confusion here. You mentioned the military courts on the West Bank, but the military courts on the West Bank would not have any jurisdiction to crimes which were committed in Israel itself. But we do have the defense regulations in Israel. And under the defense regulations in Israel, there is a basis for military courts. But then you have a problem of legitimacy. And you have a problem of legitimacy, from what I understand, is you want some kind of retroactive legislation, because you want to create crimes which do not exist under Israeli law, and even raise the possibility of the death penalty. Now, my second point is the death penalty. And I hope that Yuval will support me on this, but it seems to me that since Israel has joined the International Covenant of Civil and Political Rights under Article 6, it is prevented from increasing the use of the death penalty beyond any situations where it's done it up to now. So it could impose possibly the death penalty under the genocide or under the law against the Nazis, but it could not do so in any other case without violating international law. Thank you.
So, first question to Professor Paulson. Actually, I was very convinced by your argument about ultravirus. And actually, I want to ask you if it's possible to extend it to the ICC as well. Because in the case of the ICC, there is even more ground because Israel is not a signatory of the Rome Convention. I know that the ICC decided that he has authority, but it may be an ultra-virus decision. So for Ya'ara, I'm first of all extremely interested by your research. I want to ask about evidence law specifically, because one of the problems in post-war German criminal trials, which I studied a little bit, was the issue of proving that a specific guard at Auschwitz, for example, had killed a specific person. There are several doctrines in criminal law of joint responsibility. I'm very, very curious to know which one you think that the special tribunal should adopt.
Thank you also. So for Monica, quickly, I'm not sure I fully agree with Dave. I think courts could also engage in ultra-virus. The problem is more an institutional one, and that is who is going to determine this. But in a way, we have seen this in the Russia-Ukraine case to some extent, where the court did issue provisional measures, and then shortly later found that it doesn't really have jurisdiction over the grounds in relation to which the provisional measures were issued. So in a way, effectively, the court generated this impossible situation where it has issued a legal order without eventually it became apparent without a legal basis. So these issues, I think, are we would have to confront the legal complexities surrounding them. For Yara, I mean, I agree, of course, with Dave regarding the death penalty, which also has to do with both with changes in procedure, in changes in substantive law, and also in increased frequency. So it would be a terribly bad idea if we go in that direction. My concern about the process is really the timeline. I mean, when you look at Nuremberg, in Nuremberg by November 1945, a trial was already up and running. And here we are more than a year after October 7, and we are still debating the models and the configuration. And of course, the same applies to the Commission of Inquiry. But when you deal with criminal justice, I think there should be a sense of urgency, because at some point in time, and now of course we are not the only one in this predicament. The Americans are still litigating 9/11 trials, right? So it's, but I think it's something that has to be flagged. I mean, and maybe in some of these cases, the best could be the enemy of the good, because you also have to be more diligent. Finally, to Robert and Alexander, thank you very much for your presentation. I was somewhat intrigued by your conclusion that a clear risk finding wouldn't implicate the legal interests of the State of Israel. I would suggest that certainly with respect to the ability to obtain assistance, military assistance under the Genocide Convention and under the Arms Trade Treaty, this could be an issue. But more generally, being in a way designated by the court as a country who's allegedly or plausibly engaged in an act of genocide appears to be something which a state could claim strong legal interest that such a finding, even if it's a tentative one, would not be adopted without its presence in the proceedings.
Thank you. I see we have more questions, so in the legal interest of time, we'll take all the other questions and then you can address whichever you want. So we have Ruby, Emmanuel first, Ruby, and then Nicholas.
Thank you. As I'm not an Israeli man, I am neither categorically in favor of or categorically against what you suggest, Monica, but I'm just curious to find out a bit more as to how this notion has been applied in the European Court of Justice, for example, in particular, who institutes the proceedings and where.
Yeah, my question is to Robert and Alexander. So thank you for very well-crafted analysis. So my question is whether you would apply the Monetary Gold principle, irrespective of whether it is a totemic principle or not, to advisory opinions, because the states are in a similar position as what the Monetary Gold principle tried to prevent. Thank you.
Thanks very much. So mine's to Yara. I think I got kind of between the lines the impression that your favorite model is the hybrid courts in a certain way. So I was just wondering in relation to that. I mean, if one of the previous hybrid courts that exist in Lebanon or Cambodia, etc., was a specific model that you had in mind, and I suppose. You were mentioning that one of the difficulties with existing criminal law is it doesn't necessarily have all of these offenses, and you said you would want perhaps most judges to be non-Israeli for good reason or for good measure. Would you say the drafting of the statutes and the drafting of the offenses should also be something that is done not necessarily in-house, but done on an international level?
Thanks to Yara. What about the alternative of detaining these persons under the so-called unlawful combatants law? The idea is that there is this prospect of swap of exchange these prisoners for our hostages, and if there is criminal proceedings, the court has the authority to rule there that this person cannot be released even for a deal, and this is something that in order to overcome you will need a new legislation or something like that, which may cause troubles in addition, of course, to all the difficulties that we are facing. So it's somewhat like POW, but close to.
Sorry, another question to Yara. When we think about dealing with a challenge with, for example, creating a new treaty, there always the question of who will create the treaty. And I think that here and it relates to what Ruby said, right? So even if the pros and cons point towards this special tribunal, the one that will draft it will be the current Knesset members. And I think that you cannot avoid it when you discuss the normative implications of.
Thank you very much. Thank you, Professor Gretzmer. I know the ultra-vires doctrine has two faces. It has a good one, and it's a good one because it checks and balances on international courts. And the bad one is that it can be misused. And we have all this discussion in European Union law. We have, we have the misuse of these doctrines, limiting the supremacy of European law by Polish and Hungarian courts, and then we have the German Constitutional Court who applied it, I think, in my mind, correctly. But you have huge discussions there, and it's although a debated doctrine, but we have huge discussions there. And I think here it's always very difficult to draw the line between just an erroneous interpretation and no longer tenable interpretation. But I think here are so many indicators that it's no longer tenable because it's so the things I've mentioned. And then, but this is not all. There's also the treatment of evidence that, all UN documents are treated like they're not discussed that some evidence is problematic. The issue is just not raised. And there are so many little things that I think there's a good argument that this is arbitrary, that it's no longer tenable what is done here. And in European Union, how the ultra-vires doctrine comes into effect, it's by national constitutional courts. They apply it. And then, there's huge discussions, and It's although a very emotional doctrine in European law, but I think we need it. I think it's absolutely crucial that we have it, and we can also apply it in principle to the ICJ decisions.
So thank you all for the really engaging and interesting questions. I don't know where to start, but so I'll do it by order. As for the question of military courts and their jurisdiction, it is true that as of now we don't have a military court that has jurisdiction over Gazans, but we used to have a court like that in year 2000 in Lod. It was. Yeah, but for the jurisdiction was related to the nationality. So there was, as far as I know, there was a military court in Lod that was able to try Gazans, and it was dismantled, I think, around 2002. But either way, under the regulation, the chief of staff has the authority to establish new courts by necessity. So that, I mean, we would have to establish a new court. That's true, but that. Ability does exist under the law. As for the question of the death penalty, and Yuval, and you probably know better than me, it's true that Article 6 have been interpreted in the general comment as not allowing to reintroduce the death penalty after it's been abolished. But since it hasn't been officially abolished in the Israeli books, and there are laws that that enable it, then that it's a matter of controversy. So I wouldn't say it's that Israel can't, according to it hasn't ratified the second protocol of the ICCPR. So I think that there could be a sound legal argument stating that Israel is allowed to impose the death penalty. Again, I'm opposing it. I'm not advocating for it, but it's a claim that can be heard. As for evidence law and co-preparators, so there's what I've seen, at least in the ICTY and the ICTR and the ICTR, is a robust use of the doctrine of joint criminal enterprise since the Tadic case, and afterwards it's a really good doctrine that has been developed and that they have relied on it heavily, and I think it can definitely suit this type of proceedings. And as for Yuval's question for the time that has elapsed, and I think it's somehow also related to Barak's question, we know that there's one of the reasons that the proceedings haven't started yet, and this is real politics and what's happening in the real world, is that the cabinet is also trying to stall these proceedings because we still have hostages in Gaza, and this is also related to the discussion about the death penalty that we don't want to come out with official statements on the matter. So I know that even the people detaining these alleged perpetrators are expecting a swap of these prisoners in exchange for the hostages. So there's a fear that if we would create a tribunal and if we would come to a specific if we'll start with the proceedings and then also impose the death penalty, that might endanger the hostages. And there's a question of, I mean, if these proceedings would even take place, we'll see how many of them will be left. And as for the question of who of them will be released or not, unfortunately, or maybe not unfortunately, I think it's more of a political decision that will be decided by politicians. I don't think that they're going to legislate. I don't know, but I don't think they're going to legislate. And
government law says that the government may decide to release those who were convicted unless the court in the criminal trial ruled that this person cannot be released, period. And if the court will rule this way, it will need to enact a new law that overrule this specific.
Yeah. Can you repeat it in the mic so we can hear it?
Oh, sorry. So we were talking about which kind of detainees would be expected to be released if there was a hostage deal in exchange. And I was saying that I wasn't sure if it's a political question or a legal question or not. it's hard to answer. I don't know. Yeah, but yeah, obviously, it's open for critiques. Okay, and as for Ruby's question, I end my paper by quoting Basuni saying that we don't have a perfect international president that we can rely on. So none of these special tribunals or courts were perfect. Obviously, I was looking a lot at the Sierra Leone Special Court, which was hybrid, and again, that and the ICTY and the ICTR I think are not perfect, but fairly good examples for that. And as for who's drafting this statute, it's it's a good question. When I write about the inclusion of international justices, so I say that one of the advantages of including them is also adding expertise to the panel of people who have experience and who knows how to adjudicate these types of crimes. And we know that Israeli judiciary and international law kind of lacks this expertise. So, I mean, hopefully, if I get to ideally envision it, then I hope that these experts or perhaps potential judges would also take part in the drafting, or other international legal experts that we have here. But it's true. It's a valid point that we need to consider. Thank you.
Thank you. So we had a question for Robert and Alexander.
Yeah, so thank you very much to Yuval and Nicholas for those two very interesting questions. I'll begin with Yuval's question. So of course, I agree that being designated as having plausibly violated or plausibly having committed genocide might implicate your legal interests, as you put it. But we actually think that the ICJ has circumscribed the monetary gold rule somewhat more narrowly. So the way it put it in East Timor was that it said you're an indispensable third party if, in order to decide the claim, the ICJ would have to determine your responsibility. So really find whether you have violated your obligation or not as a prerequisite to deciding the claim. And of course, finding a risk is not the same as finding a violation. So that's where we're at. To our mind, it makes sense that in that situation where the ICJ at the provisional measure stage would find that there is a risk of genocide or risk of let's stick with genocide for that matter, that the ICJ could then say, well, there is a risk, so therefore you are under an obligation to act, which we can find at the provisional measure stage. And then at the merit stage, of course, it all depends on whether genocide in the end actually occurs. So it may be that you have provisional measures ordered against you because you're required to take action. The duty, this is what the ICJ, how the ICJ explains the structured genocide, and to our mind it makes sense, that the duty kicks in once there is a risk. Then there is this sort of in-between space where you must act, but the genocide has not yet occurred until the eventual violation occurs or does not occur. So this is how we sort of at least try and make sense of it. And to our mind, the sort of narrower standard for finding a state to be an indispensable third party particularly makes sense with considering how duties of prevention operate. Robert, do you want to take over here?
Yeah, perhaps one little add-on, because also our reading seems to be consistent with what the European Court of Human Rights does in Norway for more cases, because famously also the UK in the Zurin case argued that the United States would be an indispensable third party, which is something that the European Court of Human Rights declined. Of course, there are additional considerations because the US wouldn't be bound by the European Convention on Human Rights in the first place, but under similar obligations under general international law and human rights treaties. So this kind of treatment seems to be consistent with the conclusion that finding a risk of a violation does not trigger any kind of problem under the indispensable third party principle. Turn to Nicola's question on the advisory opinions, and it is of course true to say that states implicated in advisory opinions are in a similar position as third parties in contentious proceedings. However, I mean, at least theoretically, the ICJ always stresses the Eastern Karelia principles. So there is the consent requirement, and it cannot adjudicate bilateral disputes in advisory proceedings. That being said, we're all aware of advisory opinions which have at their core also a bilateral dispute. What the ICJ normally argues is that it does not decide that dispute, but it really gives advice to an organ of the UN, and that is something different, and it would only refuse to give the advisory opinion if it were only a bilateral dispute. Of course, there are all kinds of problems with that distinction, but I think there is one additional factor to it, and this is something that Judge Nolte has highlighted in his separate opinion to the recent advisory opinion on the Palestinian occupied territories, where he says that advisory opinions are very different from a contentious case because they are more making they're giving general advice, they don't do fact finding, and they give some certain general indications, which is something very, very different from really finding in that specific instance a state has violated its duties vis-a-vis another state. And because of that difference, also consent and the Montreal Gold play out differently. So at the end of the day, Montreal Gold does not feature as a standalone practice, only as the general bar. If it's only bilateral dispute, the court would not give an advisory opinion, but only then.
Yeah. Perhaps I may briefly sort of
really briefly, because we have and we don't have time.
Yeah,
I'm sorry.
Well, then I'll leave it at that.
You have 1 minute if you want.
No, it's fine. It's fine actually.
Okay.
I don't need to drag you further.
All right. Thank you very much. And please join me in thanking the speakers and the presentations.